So there was a Supreme Court case quite some time ago now that was the Queen versus Gladue. And Gladue was a person who was convicted of a violent offense. Finding of the court was that because of the history of Indigenous peoples in Canada, because of the legacy of colonialism, the endemic poverty, um, addiction, sometimes untreated mental illness, various other factors. The court found that the kinds of choices that Indigenous people have in their lives are more limited, and that their culpability or level of responsibility needs to be carefully examined when they're being sentenced. And so they came up with what are now called Gladue factors that when we're interviewing people, we ask them about. So, for instance, has your family had a history of residential schools? When you were a child, did you have to deal with, substance abuse with your parents, physical abuse, that sort of thing? These questions, as you might guess, can be quite personal. But because of Gladue and because of the direction of the Supreme Court, lower courts now must take those factors into account and pay particular attention to those factors when people are being sentenced. Sometimes that can mean that they get a lower sentence. Typically, it means that you get a better idea of why the person ended up before the court in the first place, and an idea of what might be appropriate in terms of rehabilitative sentences.